Good evening, everyone. I'm Professor Michelle Foster. I'm the Dean of the Melbourne Law School, and it's my great pleasure to welcome you to the 2025 Seabrook Chambers Lecture. I'd like to acknowledge that we're gathering this evening and that we teach and research and learn here at Melbourne Law School on the unceded lands of the Wurundjeri people of the Kulin Nation. And I pay my respects to Elders past, present and emerging, and extend that respect to all Indigenous colleagues with us today. Now, tonight's event forms part of the Seabrook Chambers Lecture Series, an annual lecture series established by former judges of the Accident Compensation Tribunal in the state of Victoria. Now, many of these judges had been members of the Seabrook Barristers' Chambers in Melbourne. Located in an historic bluestone warehouse on Lonsdale Street in the CBD, the name Seabrook was borrowed from the Chamber's previous use as the base of Seabrook wine merchants who began in Melbourne in 1878. The wish of these judges of the Accident Compensation Tribunal was to establish a lecture series on issues relating to the rule of law in Australia and internationally. In fact, issues relating to judicial independence, the very topic of tonight's discussion, was specifically cited as a proposed topic for the lecture series. Now, the order of proceedings are as follows. Following the lecture, there will be a chance for our audience to ask questions of our esteemed guest speaker, Justice Crowley. This Q&A will be led by my colleague, Professor Heather Douglas, the Associate Dean Engagement here in Melbourne Law School. My colleague, Professor Lee Godden, who's the Acting Director of the Indigenous Law and Justice Hub here at Melbourne Law School, will offer the final vote of thanks. But it is now my great pleasure to introduce our wonderful guest speaker, Justice Lincoln Crowley of the Queensland Supreme Court. Justice Crowley was admitted to practice in 1997 and worked as a solicitor with the Aboriginal and Torres Strait Islander Legal Service in Townsville and Brisbane. He relocated to Sydney, practiced in civil and criminal law, and as an in-house counsel with the Sydney office of the Commonwealth Director of Public Prosecutions. Justice Crowley returned to Queensland as Principal Crown Prosecutor. He was appointed Queen's Counsel in 2018, the first Indigenous man appointed as a QC in Queensland. He was sworn in as a judge of the Supreme Court of Queensland in 2022, the first Indigenous person in Australia appointed to a superior court. In his speech upon his swearing in as a Justice of the Court, His Honour said, "As I discharge my duties, I will strive to do justice in every case. To my mind, that is the most important objective of the law, and the one thing our community expects judges of this court will deliver. In the end, justice is what it's all about, always was, always will be." Thank you, Justice Crowley.
Thank you. Good evening to you all. Thank you for attending tonight. I'm really pleased to see so many of you here in person. I am delighted to have been invited to present this year's Seabrook Chambers Public Lecture. As I'm sure you know, the lecture aims to focus on issues relating to the rule of law in Australia and internationally. And that's a broad subject matter. And when I began to consider what I might talk about this evening, there was one common element that seemed central to each of the various issues that I thought would provide stimulation, provoke thought and discussion. And that was technology, more particularly how the use and effects of current and future technology poses threats to judicial independence, legitimacy and authority of our courts in the administration of justice. Technology is, of course, not a new concept. Each era and each generation of humankind has experienced its own technological developments and advances. Despite the relentless march of technology, there are some constants. There's three in particular that I want to highlight because they have significance to the topic I'll speak about tonight. First, each new development in technology builds incrementally or exponentially in some cases on existing technology. Second, the new technology improves the existing state of affairs in some way by enabling tasks to be done quicker, cheaper or at greater scale. And third, technological developments have a transformative effect on societies and the world. But in doing so, they create new challenges for society. How do we respond to the advent of the new technology? How do we maximise its advantages while minimising its disadvantages? How do we ensure that technology does not harm us? These are some of the big questions that we should be asking and thinking about in terms of ensuring that we can maintain the integrity of our democratic institutions and structures while embracing the vast array of technological advancements we have witnessed and continue to experience in the modern digital age of virtual social interactions, streaming services, e-commerce, instant messaging and communications, globalisation and viral memes. We are truly privileged in Australia to be governed under a Western liberal democratic system that respects and upholds the rule of law. And while we should rightly observe that these features of our modern Australian polity are an introduced and relatively new feature of the methods of social organisation and governance in the history of human inhabitation of this continent, we would also rightly observe that our democratic roots are nonetheless deeply embedded and have allowed our nation as a political entity to flourish and prosper for more than a century. It's those democratic foundations that have allowed our country to develop into a modern, secular society that values and promotes pluralism, individualism and personal freedoms while maintaining respect and confidence in our structures of government and our institutions. A central pillar of our democracy is, of course, an independent and impartial judiciary that administers justice according to law. These are essential features of our judicial system, necessary to ensure public confidence in the judiciary and the administration of justice. Many in our community may take all this for granted, simply thinking the system has endured so far and will continue working as it has done into the future with no maintenance required. Others may simply be disinterested or ignorant of their good fortune to exist in such an environment. Nevertheless, we, particularly those of us who are judicial officers, would like to think that by and large the general public has confidence in the role of the judiciary as an institution of government and that the citizenry, by and large, respects the authority of our courts in performing that role. And we may well be right about that. In its 2022 report on judicial impartiality and the law on bias, the Australian Law Reform Commission observed that the Australian judiciary is highly respected internationally for its integrity and its impartiality, and found that public confidence in judges and the courts in Australia is generally high. It further noted that research showed that judges take their oath of office to administer justice impartially, seriously, although they may differ as to their understandings of what that requires. But social attitudes are not static, and we must constantly monitor our democratic health. We must remain vigilant to detect any symptoms of a trend towards diminishing confidence in the role of the judiciary or declining respect for the authority of courts. And we must diagnose and treat those symptoms and the emerging threats to judicial independence and administration of justice. Many factors that threaten judicial independence are well known and understood. However, old threats are constantly evolving and new threats continue to emerge. While it may not be possible to identify a single common cause or genesis for these new and evolving threats, I would argue that there are many that are a byproduct of our modern, technologically advanced and digitally connected world. While technological developments in the digital age have allowed us unprecedented access to information and made our lives easier and more convenient, thus providing the means for our populace to engage with government and our democratic institutions, there are downsides. It is true that technology offers greater access to justice and increased efficiencies in the justice system. However, ever-evolving technology, enabling our obsession with and dependence upon social media, and the proliferation of fake news, misinformation and disinformation, the surrender of human autonomy and agency to artificial intelligence, and the seduction of resurgent political populism fuelled by online democratisation of information as a means of direct communication, all pose threats and challenges for judicial independence, authority and the administration of justice in Australia and in other like democratic countries around the world. Before considering those new and emerging threats in some more detail, it's pertinent to dwell upon some of the fundamental concepts that we have in our democratic system and remind ourselves of their importance. Firstly, the rule of law. It's a nebulous concept which defies simple definition. It can mean different things in different contexts. It's a phrase that may be used to describe an overarching political and legal ideal. And at its simplest, it can be reduced to basic notions. The law applies equally and fairly to everyone. All persons are subjected to and accountable to the law, and no one is above the law. It may also be used to express the democratic guarantee that all members of society are free from arbitrary and excessive power wielded by the state. But it's also a phrase that embodies other principles of fundamental importance, to our political and legal structures and institutions, including the doctrine of separation of powers. Now, in its simplest terms, under the constitutional doctrine of separation of powers, Parliament or the legislature makes the laws, the executive administers or enforces the laws, and the judiciary adjudicates on disputes about the laws. Although it is accurate to observe that we don't have a complete separation of powers in Australia due to our adoption of a Westminster system of responsible government, the separation of powers nonetheless is reflected in the structure of our constitution. As a nation as well, it's reflected in the arrangements and mechanisms of government in our states and territories. The three-way division of functions under the separation of powers avoids the undue concentration of power in any one branch of government and enables each other branch to counterbalance the power of another, ensuring that legal disputes about government power are resolved conclusively by an independent judiciary. Although it's often only considered in abstract terms, it is important to remind ourselves that the judiciary is the third branch of government. The rule of law and the separation of powers requires the judiciary be independent and free from interference and influence from the other branches of government, as well as from private interests or partisan groups. As former Chief Justice of the High Court Sir Gerard Brennan put it, if we are to be governed by the rule of law, we must have a judicature to administer it. The characteristics of that judicature reflect the functions it's charged to perform. First, it must be a judicature that is and is seen to be impartial, independent of government and of any other centre of financial or social power, incorruptible by prospects of reward or personal advancement, and fearless in applying the law irrespective of popular acclaim or criticism. Second, it must be a competent judicature. There must be judges and practitioners who know the law and its purpose, who are alive to the connection between abstract legal principle and its practical effect, who accept and observe the limitations on judicial power, and who, within those limitations, develop or assist in developing the law to answer the needs of society from time to time. Third, it must be a judicature that has the confidence of the people, without which it loses its authority and thereby loses its ability to perform its functions. Fourth, it must be a judicature that is reasonably accessible to those who have a genuine need for its remedies. Judicial independence is thus fundamental to ensuring the judiciary can make decisions free from external pressures and influences, primarily from the executive and legislative branches of government. It's also crucial for the maintenance of the rule of law, protection of human rights, and delivery of fair and impartial justice. Public trust and confidence in the administration of justice and respect for the institutional role and authority of the judiciary is intimately connected to judicial independence. The general acceptance of judicial decisions rests not upon coercion, but upon trust and public confidence. That requires that the public believes and accepts that the justice system is based on judicial independence, impartiality, integrity and fairness. Now, the final concept I want to touch upon and introduce is judicial authority. The concept of judicial authority that I'm concerned with here has two related dimensions. There is the institutional legitimacy of the judiciary, and then there's the authority of the courts embodied in its decisions. Judicial legitimacy is important because it ensures the public accepts decisions by courts, despite judges having no electoral mandate. In contrast, legitimacy is conferred on the Parliament via electoral mandate, whereas judges are unelected. The direct authority of the judiciary comes from the creation of courts and the maintenance of courts under constitutional arrangements and legislation. But respect for court decisions and the acceptance of the legitimacy of the role the judiciary performs to exercise judicial power to quell controversies between private citizens or between private citizens and the state, and as an institution that represents and maintains the law, derives from elsewhere. While it may be accepted that it's a complex interrelationship between society, culture and politics, it cannot be doubted that a significant foundation of the public's acceptance of judicial authority stems from the existence and acceptance of judicial independence. However, as technology advances, judicial independence and thus the legitimacy and authority of the courts are increasingly under threat. So with that background, I'll move to discuss now the influence of social media. Social media is everywhere these days, For many people, applications such as Facebook, X, Instagram, TikTok, Snapchat, WhatsApp, Telegram, to name a few, have become indispensable resources or tools for communicating with friends, family or strangers, seeking out or disseminating information, and a constant source of entertainment and amusement. Increasingly, social media is being used by government and political parties as a means for broadcasting, messaging, for online businesses and e-commerce and others to advertise and sell products and services to consumers. On one recent estimate, the 2025 worldwide digital population was reportedly 5.56 billion internet users. It's about 68% of the world's population, and of that number, 5.24 billion, or 64%, were said to be social media users. In Australia, the social media penetration is estimated to be at 78% of the population, with more than 20 million users. Now, while social media provides many benefits, it must be recognised that it has the potential to adversely influence attitudes towards the legitimacy of government institutions, particularly the independence of the judiciary and the administration of justice more generally. That's because social media acts as a force multiplier, amplifying and projecting what is often no more than the uninformed, ignorant or biased views and opinions of some to a potential audience that dwarfs the reach of traditional mass media. The democratisation of information dissemination can have both positive and negative consequences. On one hand, it empowers individuals and marginalised groups to voice their opinions, mobilise support for their various causes. On the other hand, it can also lead to the spread of fake news, misinformation, disinformation, a situation where users are exposed only to views that reinforce their own beliefs. Worse still, the corrosive effects of deliberately misleading, false or malicious information that masquerades as fact, which is then liked and reposted, perpetuated by others, contributes to this predicament. Views of that kind do flourish in the virtual world, largely because they can be expressed in an uncensored environment, and the accessibility and immediacy of social media and social networking, and because those technologies provide a veil of anonymity, allowing for some to hide behind the screen and for others to provide a fiction of celebrity status and prestige, where influencers and public figures crave ever greater numbers of followers. Social media doesn't have the same constraints on the dissemination and publication of content that are imposed upon and for the most part observed by traditional media, such as faithful, balanced and fair reporting in the public interest, fact-checking, journalistic ethics and professional standards, editorial controls, and the concern to uphold the reputational integrity of a media organisation as a reliable source of news. Instead, any social media user can be an unknown, unaccountable publisher of ignorant or uninformed personal opinion into the virtually limitless echo chamber of the internet, thus of course providing future content for AI bots to regurgitate their biased, ill-informed or deliberately misleading opinions as facts. Within that context, the way in which social media undermines judicial independence and authority are manifold. One of the most significant impacts of social media and judicial independence is the increased public scrutiny of and commentary about judicial decisions. It has long been recognised in this country that, as an aspect of the principle of open justice, the publication of fair and accurate reports of court proceedings is a common law right, and that such publication is vital to the proper workings of an open democratic society and to the maintenance of public confidence in the administration of justice. However, social media users may spread selective and biased information and opinion and criticism of judicial officers, legal proceedings and court decisions. Such users are able to disseminate their commentary and views without restriction. Furthermore, they're often not amenable to traditional avenues of recourse or remedies that the law may provide in order to ensure the proper administration of justice is not interfered with and that public and private interests are protected, such as contempt of court, non-publication suppression orders, injunctions and takedown orders, defamation actions. And it's not only the users, of course there are the social media companies, as was demonstrated in the recent e-Safety Commissioner and X-Corp decision, where although An interim injunction was granted to prevent certain content. It was not adhered to, it was not abided by X Corp, and ultimately a final injunction was not granted because it was deemed it would be inefficient and ineffective, particularly to the world at large. One common example of the effects of social media on judicial proceedings is the online commentary and discussion that occurs when high-profile cases are before the courts. Consumers of social media and users are free to express their views about how the case should be decided, criticisms of the eventual outcomes, and they do all that without presenting or even knowing the full facts and legal context in which the decision is made. Such details become irrelevant and an unnecessary waste of the limited video or character space that social media platforms permit for an audience with an equally limited attention span. Judges and courts are of course not immune to criticism, and the right of a member of the public to criticise a court's decision is well enshrined. But whereas in the past, criticisms of court rulings and decisions were primarily reported fairly and accurately to the general public by traditional media, and direct participants aside were usually only discussed and debated within legal circles or academia, nowadays social media poses increased challenges for the rule of law and the maintenance of public confidence in the independence and integrity of the judiciary, because anyone with a smartphone and an internet connection can immediately express their view on a judge's decision without any understanding at all of the legal complexities involved or the facts. It is an unfortunate trend that the use of social media in this way is used to make inappropriate, populist or contemptuous attacks on individual judges or the judicial system as a whole. This type of public scrutiny and criticism can put immense pressure on judges. High-profile cases often generate intense social media and commentary, with users often expressing strong, uncensored opinions. The direct line of mass communication to the world at large offered by social media bypasses traditional media filters and leads to a position where potentially it may influence judicial proceedings. Important cases become focal points on social media where public opinion is actively formed and expressed. And in such scenarios, judges may face indirect pressure to align their decisions with popular sentiments or in order to avoid public criticism, potentially compromising judicial independence. Judges may be reluctant to make unpopular but legally sound decisions for fear of public backlash. Politicians of all persuasions may contribute to this pressure, unfairly branding judges as soft or out of touch, or blatantly claiming that they are rogue judges who fail to properly apply the law when they disagree with the court's decision. Although such remarks are usually only made public through traditional media sources in this country, the worry that we should have here in Australia is that it's only a matter of time before social media becomes an acceptable means for such commentary. In any event, even without politicians directly resorting to social media for such purposes, their messages are inevitably reported online and on social media by not only users as individuals, but also by mainstream media providers. They are then endorsed and perpetuated in a micro-plebiscite through reposts, likes and comments by the virtual public. Perhaps more concerningly, social media platforms may engage, users may engage in unrestrained personal criticisms or may even make personal threats against individual judicial officers, again with the obvious potential to jeopardise an independent and impartial adjudication of a matter before a court. To see a current real-world example, one need look no further than the visceral attacks upon a judge recently published on social media by the President of the United States, Donald Trump, when a federal court judge ruled against the government's decision to deport hundreds of Venezuelan migrants to El Salvador on the claim that they were criminal gang members and issued an injunction to restrain the government from doing so. Trump posted these comments about the judge on his own social media platform, Truth Social. This radical left lunatic of a judge, a troublemaker and agitator who was sadly appointed by Barack Hussein Obama, was not elected president. He didn't win the popular vote. brackets, by a lot, exclamation mark. I'm just doing what voters want me to do. This judge, like many of the crooked judges I'm forced to appear before, should be impeached, 3 exclamation marks. The judge in question, Judge James Boasberg, is the Chief Judge of the US District Court for the District of Columbia and was appointed to that court in 2011. Seemingly in response to the President's post and other similar public comments made by Trump as he doubled down, the Chief Justice of the US Supreme Court, Justice John Roberts, issued this public statement. For more than 2 centuries, it has been established that impeachment is not an appropriate response to disagreement concerning a judicial decision. The normal appellate review process exists for that purpose. The comments made by President Trump not only criticise the decision of the individual judge, but suggest he is unqualified, biased, and motivated to decide cases based on his political leanings rather than according to law and in accordance with his judicial oath. Moreover, his comments question the legitimacy of the court and suggest that not only is the judge's decision wrong, but that it is illegal and the judiciary lacks the democratic authority to rule on a challenge to a decision made by the executive. Some of the public's reaction to Trump's comments show just how dangerous, in a personal sense, posts this kind can be, as they have reportedly set off a string of near-instant social media taunts and threats, including images of judges being marched away in handcuffs. And it's not an isolated incident. It has been reported that at the moment, when the judiciary in the US is weighing pivotal decisions on the legality of Trump's administration's policies, violence against judges is on the rise. Although there has not yet been an incident of actual violence, there have been attempts to intimidate judges, which, beyond social media rants, have included bomb threats, anonymous calls to dispatch police SWAT teams to home addresses, and even the delivery of pizzas, similarly as a prank, but one that carries the message, "We know where you live." Now, given that the Truth Social comments were made by the incumbent US President on social media and have been widely repeated and reported, these comments will inevitably have a damaging effect upon the reputation of the individual judge, but also upon the public confidence in the judiciary more generally in that country. And then there is the threat of executive retaliation. The Speaker of the US House of Representatives, Mike Johnson, made a media statement just this week in which he criticised federal judges who ruled against decisions made by the President, and in what might be described by some as a thinly veiled threat, stated, "We do have the authority over the federal courts, as you know. We can eliminate an entire district court. We have power of funding over the courts and all these other things. But desperate times call for desperate measures and Congress is going to act." Johnson later said that he did not mean the comment as a threat, but was instead trying to illustrate that Congress has a broad scope of authority over the courts. But it does seem that Congress is acting. Another Republican House member has already introduced a resolution to impeach Judge Boasberg. Another has introduced a bill that, if passed, would remove the power of the US District Court to issue nationwide injunctions that would restrain government decisions. The No Rogue Ruling Act, or NORA as it would be called, would limit the power to issue injunctions that restrict the actions of persons beyond the parties directly involved in the subject case. Fittingly, the House Majority Leader confirmed on X that the bill would be brought before the House for a vote next week. On a lesser scale, the use of social media by individual judicial officers also presents a potential problem for maintaining judicial independence and public confidence in the judiciary. While Australian judges do not have official social media accounts, they may of course have and use their own private accounts. The Australian Institute of Judicial Administration's Guide to Judicial Conduct notes that although there is no reason in principle to deny judges the use of social media, a judge should be aware of the risks that go with the use of social media and should act with care in light of these risks. In particular, the guide cautions a judge must remain astute to recognise at all times that they are governed by the principles of and must act in a manner that promotes public confidence in judicial impartiality, independence and integrity. Judges must therefore ensure that any content they might post, the online friends and followers that they might accumulate and the comments others might make on their social media accounts must not undermine these essential attributes. The potential for compromise is real. While judicial officers' use of social media may keep them connected to their community, on the other hand, if used inappropriately, this may lower the public's confidence in the judiciary and may give rise to apprehensions of bias. Now, another pertinent example, again from the United States, a New York Supreme Court judge was recently suspended for 3 months after complaints had been made that he'd posted on TikTok videos of himself lip-syncing songs with references to violence, sex and misogyny. Now, if that were not bad enough, in some of the videos he was apparently wearing his judicial robes, and in his court chambers, and in some others he was partly dressed and lying in bed. I'd like to think that kind of behaviour would not happen here, but it is a brave new world. Now finally, there is the alarming prospect of threats and intimidation against judges through direct contact via social media. Without appropriate use of security and privacy settings, attempts could be made to influence the outcome of a case before a court by directly targeting the judge through a publicly accessible social media application. While threatening judges may not be a new phenomenon, the use of social media may embolden, encourage or facilitate such approaches because they may be made immediately, anonymously and virtually. All of these concerns that I've been talking about with respect to social media are ultimately reflections of a broader social phenomenon, and that is the absence and disappearance of truth and facts in modern life. Truth's no longer an objective concept. It's now treated as a subjective concept. There's no verifiable, universally accepted facts. Everyone can have their own truth and their own facts. And anyone who disagrees with another's truth can simply brand their opinion as fake news. Systematic and widespread use of deliberate lies made possible by the internet and new technologies poses a genuine threat to truth as a guiding principle of public discourse. One recent study concluded that fake news is an existential threat to democracy, not because most people believe bogus content, but because of the corrosive effect it has on trust among citizens and their faith in democratic institutions representing them. But even more so than social media, the most pressing and potentially far-reaching concern for judicial independence that we now face is presented by artificial intelligence. The advent of widespread availability of powerful artificial intelligence tools and rapid technological advances with respect to its capabilities and capacities has presented new opportunities and challenges for society in every respect. There are numerous predictions that AI, together with other advances in robotics, computing and advanced technologies, will mean that many current employment arrangements will no longer exist in 20 years, with many current tasks being replaced by AI-supported processes. The legal profession and the judiciary are not immune to this technological revolution. While AI may enable increased access to justice and may assist self-represented litigants to determine if they have a viable case, and if so, to present it coherently in court, we can only hope, and may provide greater resources, time and cost efficiencies for parties and practitioners in various ways, AI nevertheless poses unique threats to judicial independence and the integrity of the justice system. As an emergency technology evolving at an exponential rate, we do not yet know the full impacts AI may have on the practice of law, the administration of justice, or upon the judicial function and judicial decision-making. However, there are already issues that have been encountered that should sound a warning, more so because the pace of appropriate regulation and control on the technology is unable to keep up with the pace of innovation in this field. Recognising these dangers, the Council of Europe has recently promulgated the Framework Convention on Artificial Intelligence and Human Rights, Democracy and the Rule of Law. Amongst other things, Article 5 of the Convention states, each party shall adopt or maintain measures that seek to ensure that artificial intelligence systems are not used to undermine the integrity, independence and effectiveness of democratic institutions and processes, including the principle of the separation of powers, respect for judicial independence and access to justice. The explanatory report to the Convention notes that amongst the concerns about the use of AI and its impacts on the integrity of democratic processes and respect for the rule of law are that such tools may be used by malicious actors to disseminate information and misinformation that could undermine information integrity and influence court rulings with potential implications for the integrity of the justice system. Of more immediate concern, which has already been encountered by courts here and elsewhere, is the potential for AI-generated submissions and argument to provide false citations of authority and legislation. In a case last year here, a Melbourne lawyer was referred to the Victorian Legal Services Board and Commissioner for consideration of his conduct after he admitted using AI software in a family court case that generated false case citations and caused a hearing to be adjourned. The solicitor provided the court with a list summary of legal authorities that had been requested by the judge. But when checked, neither the judge nor her associate were able to find any of the cases. When asked by the associate to provide copies, the solicitor did not do so. Later, when the matter returned to court, he confirmed that the list had been prepared using commercial legal AI software with a generative AI component. The solicitor explained that he didn't intentionally seek to mislead the court. He just didn't understand how the AI tool worked. He offered an unconditional apology to the court for tendering the inaccurate list and summary of authorities, assured the court that he would take the lessons learned to heart and will not commit any further breach of professional standards in the future, and asked the court not to refer him to the board. That submission was rejected. In another case, apparently due to health concerns and time issues, a Sydney solicitor used ChatGPT to draft submissions, which he subsequently filed in a migration case involving an appeal against the decision of the Administrative Appeals Tribunal. The submissions cited 17 cases that did not exist, and they also provided quotations from the subject decision of the tribunal, which also didn't exist. When the concern was raised, the lawyer filed an affidavit apologising for his conduct and explained that due to his health issues and the time constraints he faced, he decided to use AI. As a result, he inserted some words into ChatGPT and it prepared a summary of cases for him. He said that the summary read well, so he incorporated the authorities and references into his submissions without checking the details. That matter was also referred to the Office of the New South Wales Legal Services Commissioner for consideration. And yet another example of the dangers of AI, in a 2023 case in the UK, an applicant provided a tribunal with citations to fake authorities that were generated by an AI model similar to ChatGPT. It was a relatively minor issue that was at stake, which involved the applicant challenging a penalty imposed by Her Majesty's Revenue and Customs over an alleged failure to notify of her liability for capital gains tax after disposing of property. The applicant claimed that she had a reasonable excuse for her omission due to her mental health issues or because it was reasonable for her to be ignorant of the law. In support of her argument, she put forward 9 cases which she said supported her claims. The cases were not real. The tribunal member found that they bore similar names and some other similarities to real cases, but they were all fictitious and produced by the use of generative AI. Most disturbing was the applicant's response to this revelation. Although she admitted that it was possible she had used an AI system to generate the case citations, she first retorted that she could not see that it would make any difference whether they were real or not, as there must have been some other relevant cases like hers. When she was further challenged about it, she then challenged the tribunal about the veracity of the cases that it referred to. How could they be real? The tribunal pointed out that such cases were available in full text on publicly accessible websites. Now, these cases highlight 2 obvious problems with the use of generative AI to draft submissions. First, AI hallucinates. It's well known and should be well understood that AI programs may produce inaccurate and misleading content. That occurs when an AI model attempts to fill in gaps when its training data is inadequate or flawed. And second, legal practitioners need to check the veracity of any submissions provided to a court or any other documents or content to be used in a court proceedings, and cannot simply rely upon results produced by generative AI as a substitute for exercising their own judgment and diligence. There may be a fine line between time savings and efficiencies in the taking of reckless and improper shortcuts, but all lawyers have ethical and professional obligations to ensure they do not knowingly or inadvertently mislead the court or other parties, and that includes checking and verifying generated AI content. Many courts in Australia, including my own, have issued practice directions or guidelines on the use of generative AI. I was part of the committee established by my court to consider the guidelines that we would publish for responsible use by practitioners, self-represented litigants and judges. One issue that arose was whether we should require practitioners to provide some form of certification that they had used and then check the accuracy of content in submissions which have been drafted or developed with the assistance of AI. We ultimately decided against imposing such a requirement, concluding that As part of our own judicial function and duty, it was the judges who would be required to determine the relevance, accuracy and persuasiveness of any submission filed or made by a party, whether it was produced by the assistance of AI or not. And while that sounds logical, in practice all courts rely heavily on the submissions made by legal practitioners, in some cases often implicitly accepting the veracity where submissions are not challenged. The use of hallucinating AI in the absence of verification by practitioners does carry a real risk of not only disrupting and delaying cases, but could also potentially lead to courts making decisions based on misleading information, affecting both the integrity and efficiency of the justice system. In New South Wales, its guidelines in the Supreme Court have gone further, limiting the use of generative AI in a way it must not be used to generate affidavits, witness statements, character references or any other material that might be tendered or used in cross-examination. And there's good reason for these prohibitions. In a case in Minnesota, in the United States, the US District Court was considering a constitutional challenge to state laws that ban people from using deepfake video, pictures and audio clips generated with AI to influence an election. At heart of the case was a deepfake parody of then US Vice President Kamala Harris. In defending the law, the State Attorney General engaged and called an expert witness on misinformation. In a turn of events that again proves fact is stranger than fiction, and which I would again point out would like to think would only happen in the US, it was revealed that the expert witness, a Stanford University professor, had used fake article citations generated by AI in his affidavit, which is sworn in support of the state's argument. In ruling that the evidence could be excluded, the presiding judge said the citation of fake sources shattered the witness's credibility with the court. Now, although the ready availability of AI may provide greater access to justice for self-represented litigants and may assist them to marshal and present their cases with greater precision and clarity, that will only be achieved with responsible use of the technology. And there is a real risk that irresponsible use, deliberate or inadvertent, can pose serious challenges for the timely and efficient administration of justice. One particular concern, which we're yet to see, but I would venture is inevitable, is that a litigant might use AI to abusively flood the courts with meritless claims, clogging the systems and overwhelming court personnel and judges. At another level, AI threatens judicial independence and the integrity of courts through the use of informational evidence generated through AI tools. In the case of State of Wisconsin and Loomis, the Supreme Court of Wisconsin considered the use by a sentencing court of scores produced by a risk assessment tool known as Compass, which provided a prediction of an individual offender's risk of recidivism. The tool was designed by a private company which refused to reveal how the risk assessment was calculated, as it was a proprietary instrument and its workings were trade secrets. Results produced by the program are based on information gathered from the offender's criminal file and an interview with the defendant. The Compass tool calculated that Loomis presented a higher risk of recidivism. Relying upon that assessment and other factors, the sentencing court determined that a period of probation was not a suitable sentence in his case. Loomis appealed. Amongst other arguments, he asserted that the sentencing court's use of the risk assessment tools, scores, violated his right to due process because the proprietary nature of the software prevented him from assessing its accuracy and challenging its scientific validity. He also claimed that because the tool was designed to assess group data and groups' risk rather than individual risks, it was contrary to the principle of individualised justice to rely upon it. The Supreme Court of Wisconsin dismissed his appeal. The majority held that although he could not review and challenge how the algorithm calculated risk, he could at least review and challenge the resulting risk scores that were set out in the report. It didn't describe how that was to be done though, and further pointed out that to the extent that the risk assessment was based upon his own answers to questions in public available data about his criminal history, he would have the opportunity to verify the questions and answers in the report to make sure that they were accurate. The court did, however, caution that judges should be careful and exercise caution in the use of such tools, and limitations should be observed by sentencing courts so that courts could be better able and placed to assess the accuracy and give appropriate weight to the risk scores. Just how the court was able to exercise that caution without knowing how the program worked or being able to assess its validity is unknown. But despite those concerns, that tool, Compass and others, are now being used widely in the US in various ways, including in determining bail decisions in many jurisdictions. AI may also enhance the delivery of justice if it's used as a research or analytical tool to supplement the work used by a human judge. Such technology is already widely available to the general public and within the legal profession, but it's not necessarily employed or officially endorsed for use by judges within Australian jurisdictions. Amongst other things, that's because of privacy and confidentiality concerns, and also reliability and relevance limitations. In theory, provided there is a human thought and oversight of AI tasks and output, there would seem to be no real reason why AI might not be used by judges. In many ways, the task may not be that far removed from electronic legal research, whether on publicly available websites or through commercially supplied online products and collections. However, the use of AI by judges for drafting and writing judgments is more controversial. I'm sure that we're all able to recall the 2023 case of the Colombian judge who used ChatGPT when preparing a ruling in a case concerning whether an autistic child should be exempted from having to pay certain medical fees and other expenses due to the parent's limited income. The judge in that case admitted to using the AI program, but did not reveal to what extent he'd done so. He did, however, admit that he had asked it questions including, is autistic minor exonerated from paying fees for their therapies? And that he received the answer, yes, that is correct. According to the regulations in Colombia, minors diagnosed with autism are exempt from paying fees for their therapies. The judge later said that programs like ChatGPT could be useful to facilitate the drafting of texts, but not with the aim of replacing judges. He also argued that ChatGPT performed services previously provided by a secretary and did so in an organised, simple and structured manner, which could improve response times in the justice system. In a subsequent review of the case, the Constitutional Court of Colombia considered whether the judge's use of AI had violated the fundamental right of due process. The court concluded that it had not in that particular case, as the generative AI tool was not used to replace the natural judge, but rather to support the reasoning for a substantive decision the judge had independently already reached. Amongst other things, the court distinguished between two types of generative AI use. First, administrative assistance for judicial officers and decision makers. Second, for decision making. The court concluded there was no objection to judges using AI to optimise administrative or auxiliary processes, but there would be serious risks to fundamental rights if generative AI was used to substitute judges in decision making. At present, we can only speculate about the extent to which, if at all, this type of approach would be acceptable in Australia to our courts, parties involved, the profession and the wider public. Would the use of such tools undermine public confidence and trust in judges as an independent and impartial arbiter in an adjudicative decision-making process? Again, provided there is direction, oversight and verification by the judge, there may not be a difficulty with employing such technology in this way in some cases. It may not be that different from current forms of research and drafting techniques. Would we perhaps need a judicial version of Turnitin to check for AI-generated plagiarism? As the Colombian example suggests, perhaps the most contentious current and future issue with respect to the use of AI by judges is its use in decision-making. Many argue that AI should never replace a human judge as a decision-maker, at least in serious or significant cases. None the least because the administration of justice, according to law, is a uniquely human endeavour and must remain so, as it requires the decision-maker to draw upon their inherent human intuitions and capacities for compassion, mercy, morality, sensitivity to social norms and common sense, to name a few, in order to determine what is just and right. However, the use of AI in the courts and in judicial decision-making to some extent is inevitable, and it's already started, as already noted, not only in the US, but in other countries as well. One fundamental issue with respect to the use of AI in judicial decision-making is the question of the legal authority of the decision-maker. Who will be the decision-maker if AI is employed? Is it the human who inputs the data, or the computer program or the system that outputs the result? Is it the programmer? Is it the policymaker or the legislative body that endorsed and authorised the use of the technology for this purpose? Regardless, Will it be acceptable to the parties and the broader society that such agents or actors are imbued with the authority to exercise judicial power? If so, will this impact upon our notions of judicial independence and the rule of law? Will the checks and balances inherent in observance of the doctrine of separation of powers be eroded? Another concern is where and how AI judge decision making might take place. Would it be a type of e-justice, entirely automated and online, where details are simply inputted by the parties and a results then displayed on a screen somewhere? This potential for having damaging effects on society through the absence of a public forum for the administration of justice cannot be underestimated. Justice must not only be done but seen to be done by a judge undertaking a public hearing and engaging in a deliberative decision-making process. An e-hearing will not have those features. Similarly, the transparency and accountability of the justice system is maintained by the essential requirement that reasons for decision are given by decision makers. Such reasons not only allow the parties to know how the case was decided, whether they may have appeal rights to exercise, and for appellate courts to determine such appeals, but they also perform vital functions in terms of precedent, public education, may even influence future legislative choices and policy development. Will AI judges provide the same level of transparency and accountability, exposing their reasoning processes, and fulfil the same functions for society? The use of AI judges would also inevitably lead to a decrease in the need for human judges. A potential consequence of that would be that the legal community as a whole would diminish. There would be fewer lawyers, fewer law students and academics, and fewer people invested and engaged with the law. As a result, the community as a whole would tend to care less about the law, it's been suggested. That's because the contribution that judges make to society extends beyond adjudication and includes the important and often unexamined issues relating to compliance and acceptance of the rule of law. The development of the law would also suffer. Lawyers and parties would be less likely to invest time, effort and money into cases that are test cases or novel arguments or litigation if there's no possibility that by doing so they could shape the result. As a consequence, the law may not provide an adequate or suitable response to new issues and may not develop in ways that reflect changes in social attitudes and values. Another major concern with the use of AI technology in judicial decision-making is the prospect that it may of course be susceptible to manipulation and external influence to benefit certain classes or persons or to favour certain outcomes in particular cases. AI is big business. Corporations that design and provide commercially available programs will understandably seek to protect their intellectual property and keep secret any commercially sensitive data or information, as we saw in the Loomis case. But without any transparency as to how the programs work, how can they be accepted? While it might be understandable from a business perspective, the opacity of such decision-making comes with the inevitable risk of controlled or curated decisions designed to protect or promote certain interests that sit squarely outside the interests of the public and the parties. We can take the new Chinese AI application DeepSeek as an example, perhaps. While it's touted as providing a better, faster and cheaper capability than ChatGPT, it's quickly discovered that it had been trained to avoid politically sensitive questions. When some journalists asked it what happened at Tiananmen Square, it responded, "Sorry, that's beyond my current scope. Let's talk about something else." Now, it's not quite, "I'm sorry, Dave, I'm afraid I can't do that," but it's just as chilling. The capacity of the courts to perform their function free from interference and dependence upon any persons or institutions, including the executive arm of the government or commercial interests, may be impinged where AI tools are chosen, operated or owned by third parties. A final area which is of particular concern is in the decision-making involving the exercise of discretion. Many judgments within the legal system involve decisions of that kind. Sentencing is a classic example where a judge must undertake an instinctive synthesis of a range of considerations to arrive at an appropriate result. While humans may be suited to this kind of decision-making, involving evaluation and weighing of competing factors, AI judges may not. Computer programs operate on logic and inputted information is processed via algorithms to produce an outcome that is predetermined. Such a process is ill-suited to discretionary decision-making. One possible way to accommodate this apparent shortcoming, and one which does not augur well for judicial independence, is that parliaments may remove or reduce discretionary decisions and judgments, including by imposing prescriptive lists of factors that are to be considered by a decision maker and which, if satisfied, provide certainty of outcome. Such an approach would improve the availability of an AI judge to produce a valid outcome, while at the same time providing the justice system with greater efficiency in decision making. One can imagine a future political environment where those features of the justice system would be attractive and provide an alternative to a system in which human judges decide. Now, arguably, the prospect of the greatest threat to judicial independence is posed by political populism. It's an ambiguous term, but can be understood for present purposes to refer to that brand of politics or political strategy that strives to appeal to ordinary people who think their concerns are disregarded by established elite groups and traditional institutions. It focuses on tensions, real or contrived, between the pure people and the corrupt elite. Populist politicians seek to directly communicate with and channel the people, uninhibited by traditional political structures and modes of representative government. As an institution of government, the judiciary can be viewed by populists as an impediment to their political agenda. Populism is not new, but there has been a resurgence of political populists in many Western liberal democracies in recent times, spurred on in part by the use of social media and the internet. Yet again, we look no further than the United States and the first and second presidencies of Donald Trump as a prime example, but there are others too that seek to appeal to populism. Marine Le Pen in France, Benjamin Netanyahu in Israel, and even Clive Palmer in the Australian political landscape. A binary moral classification is common to all populist rhetoric, but the identities of the vilified elites will vary. To a populist leader, anyone who opposes their views or decisions is morally bereft, inherently illegitimate, and an enemy of the people. Commonly, traditional mainstream political opponents, journalists, academics, artists, and of course judges are singled out. Invariably, the sowing of division commences by branding such groups as individuals who are extremists or radicals, so that they can be clearly identified as enemies of the morally pure people who pursue political, social and cultural ideas that are at odds with common sense and the general will of the people. The clear message is that such people are corrupt, self-interested elites who are beholden to minority groups or interests who hold dangerous ideas that are out of touch with the common person. By attacking those who occupy positions of power in society on moral grounds and accusing them of serving special interests, populist actors are able to capitalise on public dissatisfaction, fear and resentment in order to serve their own wide-ranging political agendas. In doing so, they seek to exploit the perception that parliamentary and party politics fails to provide adequate representation for some key portions of the population. This theory poses a threat to liberal democratic institutions that constrain majority rule and, by extension, a populist leader's powers. The courts are no exception. Populists seek to abolish or restrict such constraints, which they consider to be illegitimate impediments on laws, policies and actions that they claim seek to implement the general will of the people. Courts are seen as a barrier to the will of the people rather than providing a legitimate check and balance on other branches of government. There is a trend amongst populist leaders worldwide to employ a range of measures that seek to threaten the independence and the proper function of the judiciary. That includes adverse remarks in public and on social media, and also more extreme measures like constitutional amendments, manipulating the composition of courts through meddling with appointment processes, retirement ages, the removal of jurisdiction in certain matters. Such measures are all designed to interfere with the independence of the judiciary as a constraint on government power. In this way, populists seek to exploit the relatively weak democratic position held by the judiciary and ignore the rationales for a constitutionally enshrined separation of powers between the three arms of government. Members of the legislature and the executive can claim moral supremacy as democratically elected officials representing the people. Judges, on the other hand, can be easily criticised and ostracised as unelected public servants who have no authority to defy the will of the people. There can also be politicised judicial appointments. Again, Many of us may believe that we have witnessed the effects of a politicised judiciary with the US Supreme Court's decisions in Dobbs and Jackson Women's Health Organisation, which overturned the Roe versus Wade decision, guaranteeing constitutional right to abortion, or Trump in the United States, where the court found presidential immunity from criminal prosecution presumptively extended to all of the president's official acts. These and countless other examples are the kinds of approaches being adopted by populist leaders around the world to limit the ability of the judiciary to review and provide oversight of government decisions. Potential detrimental impacts of modern forms of technology on judicial independence and authority should not be underestimated. If these ever-evolving innovations are allowed to dominate our lives and our social and political interactions unchallenged and unregulated, we run the risk of allowing a fundamental cornerstone of our democracy to wither and decay. Anyone who values the freedoms, rights and protections afforded by a liberal Western democratic society such as ours cannot idly sit by and allow that to happen. While it's not all doom scrolling and gloom, we can take action individually and collectively and institutionally to maintain our society's adherence to the rule of law and the public's confidence that justice will be administered fairly, impartially and with integrity by an independent judiciary. I would argue that to avoid the pitfalls of the examples I've discussed, the primary action we can take is to consolidate and build upon our democratic strengths to further enshrine the rule of law within the legal, political and social framework of our society. This can be achieved primarily through promoting greater awareness and understanding of our system of government and the place and role of the judiciary within that system, increasing public education about the work of judges and the judicial process and why judicial independence matters is paramount to retaining the faith and confidence of the public in the administration of justice. Encouraging widespread understanding of the judiciary's role in democracy fosters a culture where citizens will stand up for judicial independence and hold political leaders accountable when it's threatened. Concurrently, governments can develop further policies and implement laws that strengthen the institutional role and independence of the judiciary, ensuring that the separation of powers is not infringed and that judicial officers will remain free from political, executive or other interference in the discharge of their duties. To combat the potential dangers posed by technology, governments can devise legal and ethical frameworks to identify and counter the use of social media and the spread of fake news, misinformation and disinformation, and to guide and regulate the responsible use of generative AI. All branches of government should take the lead in establishing and enforcing guidelines, codes of conduct or standards to be observed by their members. Similarly, organisations and institutions across society should be encouraged to adopt their own policies, rules and guidelines to manage the responsible and ethical use of these technologies. And of course, the judiciary and judges have a role to play in all this. Judges will do so by maintaining high professional standards of judicial behaviour and ethics and deciding cases with integrity, impartiality and independence and with rigorous intellectual application. We may still be some way off from a future in which Skynet comes online and takes over. That was 1997, by the way, in the movies. However, we must remain vigilant to ensure that technology enhances and enriches our lives in ways that we do not damage or destroy our democratic ideals and institutions in the process. In doing so, we must strive to ensure that judicial independence can adapt to the challenges of the digital age so that public confidence in the administration of justice may endure. Thank you.
We're running a bit behind time, but we do have time for a few questions. So if there are any questions, please let me know and we can bring the microphone to you. There's one fellow in a black shirt in the second row here.
In the first kind of segment of the seminar, you kind of talked about social media and the impact it has on the backlash of social media on judges for court decisions, right? But my question really is, do you reckon some of that backlash could also come from the fact that the legal system is very complicated and very essentially too complex for everyday people to understand, so then they often go to media, they often go to social media for their understanding of the court case, which leads to a lot of the disinformation?
Yes, I do agree with that. You're right that most people may not know the complexities involved, and they may not understand the full context in which decisions are made. It's unreasonable to expect that every member of the public might go and read a full judgment and then have that in mind when they discuss the implications.
So would there be like, would the courts be able to work on something that would actually be able to improve everyday person's comprehension of judgments or judge cases? Because I know there's like judgment summaries, but those are very few and far between, and I've kind of looked at them, and it's very hard to find.
Yeah, well, I gave one the other day, a judgment summary. It was 3 pages and the judgment was 489 pages.
I'll definitely give it a look.
Yeah, I didn't want to write 3 more pages, but it was important because for everyday people to understand what decision had been made and why, that small, short summary in plain language was invaluable. And I think courts can do that more and should do that more, and we'll see that happen more often. And also, I think you'll see other technology being used so that courts can communicate and educate the public about decisions and the work of the court. So in some of the decisions in my court where judgment summaries are made available, they also have a QR code which links to the judgment and people can access it. At the moment though, those things are often only being used by media, the mainstream media, as a means of being able to get a quick summary of a case to put into a news article. But we would hope to be able to develop ways in which we can communicate that more broadly to the public using the technologies that everyone else is using.
Yeah, thank you very much.
I think there's time for one more question. I think you've got a question.
Thank you very much for your address. Very interesting. Can I ask you, with regard to social media impacts, have you yourself been the subject of such attacks, perhaps by reason of your Indigenous ancestry? Recalling, of course, that in Queensland, historically, Indigenous people have not been well treated, especially during the Bjelke-Petersen years.
Yes, to an extent, but largely I don't have social media, and that's one of the reasons. I did get some people making unsolicited contact and posting me things when I did have a social media account. But I also had people on the other side imploring me to act and to do something in their case. And again, that's equally inappropriate. So the end result is that I just don't go on social media. So to an extent, I'm immune in a way, or removed from some of that criticism and commentary which might happen, but also the direct approaches that might come with it.
Yeah.
We might leave it there, but I'll hand over to my colleague, Professor Godden, for a final thank you.
Thank you very much, and I can tell from the interest that's been generated and people wanting to follow up just how you've touched a chord of interest. And I'm here to deliver the vote of thanks on behalf of my colleagues in the law school, but also the Indigenous Law and Justice Hub, which is an initiative within the law school that is seeking to advance not only in legal education but in the legal profession more generally the interests of Aboriginal and Torres Strait Islander peoples. And I think that last question was just an indication of the general community support for those processes. And I would like to say, as my vote of thanks, I've also just come in from teaching native title, and I was teaching the Native Title Act and the WIC amendments, and as part of that, the furor that erupted around the WIC decision and what was then a lot of adverse media comment. And Chief Justice Brennan, I remember in news clips supporting the independence of the judiciary in that context. And I think you have given us another context in which that challenge to the judiciary will be there and the importance of independence. So thank you very much for your lecture and your presence here. So if everyone could join me in thanking Giselle.